Alex here with part 221 of the My Docket series on child custody and visitation. As for my previous videos, I'll take this opportunity to invite my viewers to take a look at part 0 if you haven't seen it yet. That's a video that contains a detailed disclaimer and the underlying purpose of the series. Two things that I will glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened. That's because my parental rights have been terminated. Number two, the nutshell version as to the purpose of the series to give my viewers one big example of my 8-year-long high conflict child custody ordeal from beginning to end in chronological order. We go into the court's denial of my motion. My mindset was very negative. I felt I was upset, even angry, and that's mainly because of the letter from the Secretary of Treasury. If it wasn't for the letter from the Secretary of Treasury, I would have been disappointed, but I wouldn't have been as outraged. The reason why it was so upsetting is because the Secretary of Treasury took the time to actually put together a letter, and they could have said, "No, we're not going to give this money to you." They could have said, "We'll give this money to you, but you're supposed to comply with this other procedure." But no, they didn't say that. They said, "We're standing by from an order from the judge," which is like, okay, this is going to work out. The Secretary of Treasury has recognized what I'm trying to do, and they have stated, "You're doing the right thing. We're just going to wait for that judge." And that is what really got under my skin. That's what really underlined my perception that the judiciary just has an issue, an axe to grind with non-attorneys. And that's in large part why I did the video, self-representation bias. If I did have an attorney, the judge would have probably granted the motion. I very strongly believe that. If I did have an attorney, or if we had a situation where maybe I was the female, I talk about that in the video, gender bias. There's just this strange issue with judges, how when it comes to a female or a mother asking for money, they're much more inclined to grant it. When the father or a male is doing the same thing, they just, for some reason, it just weirds them out, and so they just don't do it. If you want to learn more about those two different types of biases, please watch my videos on the topic self-representation bias and gender bias. Anyway, I think we're going to get more out of this video by actually going through the documents, so let's go ahead and take a look at what I have filed. Here we have the judge's order denying September 5th, 2018 motion. Standard introductory paragraph. The court is recognizing that I filed a motion for designation of entitlement to property held in the custody of the Unclaimed Property Division. On August 9th, the court entered its order granting motion for costs. That's my $500 cost award. I'm now asking the court to obtain a designation of entitlement to my ex's property held in the custody of the Secretary of Treasury, and to allow me to obtain the information of any and every depositor to have turned funds over to the State Collection and Disbursement Unit. Okay, I almost forgot about that portion too. That wasn't as surprising. I think the judge is flat wrong, but it wasn't as surprising. And again, I still think my arguments on gender bias and self-representation bias apply to this here. I think if the gender roles were flipped and if I was the mother, they would have granted that, which is completely wrong, but that's what some judges do. Going into, let's see. In this case, I was awarded $500. The court finds that I have not established that the court is required to designate that I am entitled to property. Okay, so she doesn't, see how she doesn't cite a statute here? She's just saying it. She's just saying that I'm not entitled, but she's not saying why. There's no statute, there's no rule, there's no case law, that's just her opinion. I can proceed as a creditor to enforce the judgment. Okay, this is wrong. So this here, the judge is saying, what she's saying, that I can file a writ of execution and treat them like any other entity, I guess you could say, and that I could execute money in that fashion. You're gonna find out more about why the judge is wrong when I go through one of the appeals on this, because there's actually another case in the Supreme Court by another person who actually tried to do this. He tried to serve a writ of execution on the Secretary of Treasury, and he failed, and the Supreme Court explained why that was the wrong mechanism. So the mechanism that I'm trying to use is the correct one, but the judge doesn't know that, or at least she's saying that she doesn't know it. She hasn't indicated that she's read the letter from the Secretary of Treasury, so there's a chance she just didn't read everything. And so, I mean, that's just sloppy, which I don't know if that's worse or better. then what's going on here? Either sloppy or incompetent. Next section we have, I'm not entitled to examine a third-party state agency regarding where deposits are originating from based on a cost award in this case. Why? She notes that I am not seeking discovery regarding the judgment debtor's assets because I'm stating that I know the alleged assets are temporarily held by SCDU. What? I didn't say that. Okay, so then she's citing an inapplicable case. Rock Bay LLC versus District Court. So here in Rock Bay LLC versus District Court, the judge refused to quash a subpoena where the judgment creditors did not demonstrate anything about the relationship between the third party and the judgment debtors that raises suspicion sufficient to require access. Well, I did do that. I'm trying to find out information about my ex's employer, which that's the connection. She works for them. And why am I doing that? So I can get a writ of garnishment sent to the employer. So the judge is citing this case and she's trying to say that this is analogous with my case, but it's not. It's just completely wrong. I'm also not alleging that I can enforce the judgment against those child support payments. What? Yes, I am. So she's reminding me of Judge Weller. She's just saying a bunch of stuff without any basis. It's just really messed up. Next, we have that the court finds that the Uniform Unclaimed Property Act sets forth a process for obtaining unclaimed property. I am submitting that I have proceeded with filing the claim. The court does not have the authority to dictate or designate. So again, she's wrong. She's just ignoring the statute that allows her to designate it. It reminds me of when when Judge Weller put together this crazy order that just kind of twisted himself into a logical pretzel to find a way to get to the conclusion that he wanted to, which was to deny my motion. She's doing the same thing that Judge Weller did. I talk about why judges do this in 2 videos. The first one is meta rulings, but I think the more on point one is conclusion before the facts. This is not that uncommon for family court judges to do this. They just decide what conclusion they want to reach, and then they twist themselves into a logical pretzel to get there. Certificate of service under Rule 5, indicating this document was mailed to my ex. Okay, we have my notice of appeal. That didn't take me long. So I filed a notice of appeal to the Supreme Court of Nevada. Rule 5, certificate of service, indicating this document was mailed to my ex. Next document, case appeal statement. I've gone through these a bunch of times, guys. I'm not going to go through it again. It is very standard. It goes through the exact same lines, and it just tells the court, the lower court, information like who's the appellant, who's the respondent, what are the addresses of the attorneys, stuff like that. Here's another case appeal statement. This one was filed by not the Supreme Court clerk, by the district court clerk. And the reason why the district court clerk did this is because the rules of appellate procedure require the district court clerk to do this when a non-attorney files an appeal. So since I was not an attorney, the district court clerk had to do this to comply with NRAP 3 subsection F. Same thing for the most part. The only difference might be that she says that it is a child custody case and I say that it isn't. The reason why is because, yes, it's a child custody case docket-wise, but the issue that I'm taking to the Supreme Court has nothing to do with child custody. It's about seizing money that's held with the Secretary of Treasury. Same thing that I've mentioned before on these. Nowadays, with the experience that I have, I would not have filed a case appeal statement. I just comply with the rules and let the clerk of the district court do it for me. Next, we have the certificate of clerk and transmittal. This is just the clerk indicating that she is sending all of the documents to the Supreme Court as is required under the rules of appellate procedure. And again, I think this is because 99% sure this is because I'm not an attorney. If you have an attorney, they want you to file something known as an appendix. But if you're representing yourself, they just transmit the entire record to the Supreme Court. And this only applies to appeals. So if you're filing a writ petition, they don't care that you don't have an attorney. If you're filing a writ petition and you don't have an attorney, you still have to prepare the appendix. Nothing is going to transmit. Going into the aftermath, I filed, it looks like 1, 2, 3 documents. One of those was not a free filing. That's in the notice of appeal. So that's going to be $250 in costs. My ex didn't file anything, so she incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. My ex didn't have an attorney either, so she incurred $0 in attorney fees as well. As my previous videos, feel free to post any questions you have down in the comments below, and I will see you guys next time.